So this afternoon's panel is about a very important topic, achieving safety objectives through case law, statute, and procurement processes. And I would really emphasize the importance of these different instruments, of course, the common law and statutory interpretation and application by the courts, by the TCC and the courts more generally, the statutory interventions, of course, the Building Safety Act, and importantly, procurement. I am truly delighted to welcome again to King's College London Dame Finola, the Honourable Mrs. Justice O'Farrell. She gave the keynote speech in September 2 years ago, I think, or 3 years ago. We were still entirely online. I'm delighted to welcome her in person to King's. Dame Finola was called to the bar in 1983 by the Inner Temple, took silk in 2002, and soon afterwards, in 2007, was appointed as a recorder, and then made a Justice of the High Court, Queen's Bench Division at the time. In 2016, assigned to the Technology and Construction Court, part of the Business and Property Courts. Prior to her judicial appointment, she had 30 years experience as a leading barrister in construction, engineering, energy, shipbuilding, and information technology cases. She's the judge in charge of the TCC, and I hand over to you, Dame Finola, for chairing this panel. Thank you.
Good afternoon, everyone. It's a pleasure to be here. As the Grenfell inquiry hearings have drawn to a close, amidst the recriminations and the blame games, it's important for us to look forward to the ways in which we can achieve building safety for the future. And in this session, we're going to consider how building safety can be achieved through case law, through legislation and regulation, and importantly, through procurement, so that the buildings are safe from the outset. Our first speaker today is Professor David Mosey. He is a professor of law and former director of the Centre of Construction Law and Dispute Resolution. Before joining King's College London, he was the head of projects and construction at Trowers and Hamlin LLP. His research interests focus on the interdisciplinary relationships of construction law with the evolving practices of procurement and project management. This includes research into partnering, alliancing, joint ventures, and other models for collaborative working. And he has established King's College London as an academic partner of the Constructing Excellence and the Cabinet Office. In 2021, the UK government commissioned Professor Mosey to undertake an independent review of construction frameworks and adopted the findings of his report, Constructing the Gold Standard. Professor Mosey is also exploring the impact of construction projects on communities and was commissioned by the UK government to lead their new procurement guidance to support building safety following the Grenfell Tower disaster, launched by Judith Hackett in 2022. This afternoon, he is going to talk to you about a system of public and private procurement that will reduce risks and improve safety.
Thank you very much.
Hello, everybody. Look, my first slide says this: building regulations are not the only issue. It is important that they're updated, and it's important that they do a better job than they've done in the past. But I hate to tell you this, ghastly things could still happen, and finding that someone has breached the building regulations and punishing for it will look like a very poor remedy. For this reason, Dame Judith Hackett, who I hope we're all familiar with, she did a very important independent review called Building a Safer Future in 2017, looked at procurement issues as well as regulatory issues, and said that the problem substantially is indifference to quality and safety. Strong words. She said the motivation is to do things as quickly and cheaply as possible rather than deliver quality homes that are safe for people to live in. I've worked a lot in private practice in social housing, and I thought I was on the side of the angels. I thought we were all the good guys, we could do no wrong. Like some of you, I've been watching the ITN news over the last 2 years, which has been pretty alarming in terms of what social housing is doing, and like you, I'm still in shock from the Grenfell Tower five years ago. So something is wrong, and the question is, can it be put right, and how can it be put right? So Dame Judith said, improving the procurement process will play a large part in setting the tone, and it will be the place where the drive for quality and good outcomes, rather than just lowest costs, must start. And for those of us who think, say, yeah, absolutely, how right, think that our traditional procurement models are based on lowest price, firmly based on lowest price. You've heard this yesterday, and tinkering with the evaluation criteria is only one aspect of adjusting that perception. So Dame Judith said the procurement process kick-starts the behaviours that then we see throughout design, construction, occupation and maintenance. She made this very clear. And as a result of that, I became involved in this new guidance. It's interesting. Where does that go? There we are. This guidance was launched by Michael Gove, who was Secretary of State back in January of this year, and he's Secretary of State again for levelling up homes communities. Let's hope he stays there. I was talking to one of his civil servants yesterday who said they were delighted he was back. Not sure every civil servant will say that about every minister, but that's another question. Delighted he was back. He was a man of action, and he really, really took the consequences of Grenfell very seriously indeed. So he launched this in the House of Commons. It was then launched by Dame Judith Hackett online, as everything was online in the spring, with some 500 people there, and you can actually watch the YouTube video of the launch. And it is, interestingly, described as guidance on collaborative procurement for design and construction to support building safety. And you will think, hang on a minute, is that David just getting the word collaborative in there because it's a thing that I have done? No, because what we're going to do in this guidance and today is unpick exactly what we mean by that. It is not a wish list. It is not a way of being nice to each other. It is a name for a set of key processes and relationships that, in my view, would have substantially reduced the risk of the Grenfell disaster. Substantially reduced that risk. And therefore, it might be worth us all taking a look at it. We have support for some interesting bodies who were involved in this guidance. We have Chartered Institute of Builders, Chartered Institute of Procurement Services, I've forgotten, Purchasing Services, I've forgotten already, Constructing Excellence, Crown Commercial Service, a leading social housing provider, L&Q, the RIBA, the RICS, Trowse and Hamlin Solicitors, an interesting group there, mainstream players. Why would they support something that specifically focuses on collaboration as a solution to something as ghastly as the risk of fatalities in a construction defect, range of construction defects and a consequent fire? Why would they do that? At a time when we have a Building Safety Act and we have secondary legislation underway that is looking at some gateways, as you may well be aware. Gateway 1 at planning application stage, Gateway 2 before building work starts, Gateway 3 when building work is completed. Well, that does it, doesn't it? People submit their details, those are assessed by the building safety regulator. What's the role of collaboration in this? Is it just a bit of a complication? Well, I'm going to do something wholly inappropriate, which is just make passing reference to what we've seen on our televisions during the public inquiry, because it shocked me as much as it shocked you. We need teams assessed on balanced evaluation criteria rather than a race to the bottom. So those of you who heard Studio E architects say they had never been engaged on a social housing refurbishment project before can safely assume that cost had something to do with their appointment. We should have contractors and suppliers appointed early on a conditional basis so that they can improve and agree safety proposals and reduce risks. Ryden were appointed under a single-stage design and build contract. They submitted a price. They were then asked to reduce that price. Those are facts. They're in the public domain. They were not appointed under a two-stage process. That gave no opportunity to connect the design views of Studio E with the propositions of a cladding manufacturer and to test through due diligence whether this was making sense and whether the cost savings sought by the TMO were sustainable or indeed safe. Design, construction and operation should be supported by a golden thread of digital information. This is Dame Judith. This is BIM. This is the idea that we need digital records. Now, part of the problem in Grenfell was that nobody knew where anything was. It's the problem in an awful lot of buildings. And people, having completed the refurb, walked away. Defects liability over, off we go. Next project. That's what everybody does. Now, if they're not appointed to operate, and not everyone is going to be on a DBO basis, if they're not appointed to operate, what are they supposed to do? But if they're not commissioned and required as a team to create digital information and to share it, you will get a great big paper repair and maintenance manual that somebody might read. But nothing gives you checks and balances. So that is what collaboration is. It is balanced evaluation criteria, it is early engagement, and it is integration through collaborative contracts linked to resident consultation. I think you've heard and seen that the residents were not consulted, whatever they said. Again and again and again, nobody consulted them on the refurb works. And there is a lack of information. So, I know I'm not telling you what you don't know, but I'm telling you that there are procurement systems that deal with that. It doesn't have to be that way. Now, the guidance is entirely neutral as regards contract forms and as regards procurement procedures. It is not embedded in public procurement because an awful lot of housing development is done by the private sector in their own way and through their own contract forms and with their own supply chains. But that doesn't mean that they should not be subscribing to those four key principles. And the idea in this guidance is therefore that you take those four reforms, requirements, norms, good practice. I don't know if anybody would tell me that those four things are not good practice or are unnecessary, and you embed them in the three gateways that the Building Safety Act is now going to introduce through secondary legislation. It is as simple as that. The guidance, which you can download, goes through the different questions that apply at each gateway, and I'm going to do that very briefly now. And I'd be very interested to know if anybody thinks this is daft, marginal, irrelevant, we all do it anyway, because I don't think any of those things apply. And this is serious business. I'll tell you why I'm speaking in this tone. I find it quite surprising that social landlords are not over this like a rash. I told you L&Q sat on that group. I know a lot of social landlords who are very responsible and thoughtful procurers who do these things already. But not everybody. Not everybody. So we want it legislated. You can see this coming. So fire statement. Planning application should be accompanied by a fire statement. Has the selection of the fire statement consultant been lowest price or on balanced criteria? Be nice to know that you're getting someone who's good doing the fire statement. And then for the professionals preparing the planning application, have they got competence and have they made contributions to health, safety and quality compliance? Have they integrated those? I got a little bit of feedback that, hey, it's just planning. It's just planning, and the people who do planning may have nothing to do with the implementation of the project. And that was from DHC who told me that. I thought, the most extraordinary thing. So, we want, surely, the people who apply for planning to have some involvement in the delivery of the project they've got planning for, and to have been appointed on the right basis, and even at that early stage, to be competent and committed to digital information and able to deliver something that is a digital record for future users, occupiers, maintainers. Then we come to the principal, designer, principal, contractor, familiar terms from CDM, we're not changing any of that, and the wider team of professionals who are putting up the Gateway 2 building control application before we start on site. So we've got the planning, and we've done the best due diligence we can. Now we're revving up to build. And we want to know, surely, that the people who've prepared the plans, the construction control plan, the fire and emergency file, have demonstrated, again, a balanced approach in the way they've been selected and evidence of suitable skills, knowledge, experience, and behaviours. That's due diligence in selection, but getting that clear so that we are not just filling out a little form and then going for the lowest price. We're actually trying to understand what those parties offer is reasonable. Then we get to something that is crucial. This is mandated by government on a comply or explain basis. Early supply chain involvement, which is an evolution of early contractor involvement, is a requirement now. I've been lobbying for that for a very, very long time. Every contract form provides for it now, but it's sometimes seen as an option, and I find that quite bizarre, because if you don't have that early appointment, you do not have the ability to share consultant designs with manufacturers of cladding or other matters, cladding manufacturers' proposals to share with design consultants, assessment of cost versus risk versus program, all of the things that you would want to do. You cannot do it in a single-stage arm's-length tender at the last minute. It's a short, sharp consent. It is not a proper process. So early supply chain involvement is the big change, as far as I'm concerned, in a procurement process, not if you feel like it, but as a matter of necessity. We then get to the recognition, absolute basic, of legal obligations as duty holders, which are clear in the Act and are going to be clear in the secondary legislation, but we want confirmation that these obligations are being fulfilled in relation to safety and quality compliance, and again, demonstration of competence and capability in relation to digital information management, just in case people forget, say we're good at other stuff, but we don't do BIM. Is that all right? We're so far down the track of knowing that digital information is more reliable and efficient and integrated that no, it's not all right. We then get to what I've described as a collaborative system, but this is consultation with residents and consultation with other team members. Pretty reasonable in the run-up to start on site. If it's a new build, I appreciate you haven't got any residents to consult, but a lot of this is refurbishment, and residents, in my experience, have a lot to say and offer. So they should be built into the process properly. And again, transparent decision-making, so that we see how a client and designers and contractors have reached their conclusions. Not discounted, not authoritative, not let's just stick all the liability on one party, that will do the trick. Regular consultation as we go through the life of the project, so that we've got a golden thread of information, so we've got a build-up of information as the implementation of the construction control plan goes ahead, and so that we're ensuring continued compliance. You're not expecting the building safety regulator to monitor any project, but evidence of that continued compliance is pretty important as you come towards Gateway 3. And we come to Gateway 3, and we want to know that the as-built plans and the other documents are the ones that we thought we were going to get, and that they too are compliant with the safety regulations and the approved quality. We want to know that before work is covered up, and we want to know it before work is handed over, and we want a golden thread of information handed over to the operator. Now, that is pretty prosaic, simple stuff. And there's this big opportunity now to build it into the legislation so that procurement, regulatory compliance, legal obligations sit together and are not seen separately. Coming to the end, I touched on the construction playbook yesterday. I commend that document to you. It doesn't bind housing associations or local authorities, but it is relevant to them, and it certainly binds government departments. And Ministry of Defence builds housing. A lot of people build housing, so it's important. They picked up this guidance in their September update. That's the guidance, by the way. Hold it in my hand. And they said, This is government, and with 49 industry organisations supporting them. They said that you do have to procure projects and contract management to ensure the right behaviours, and that you do need visible and collaborative leadership. And they commended this guidance to anyone who is engaged on a project or higher risk building that is in scope for the building safety regulatory regime. Good. I'm delighted they did that. They, as I say, mandate their reforms on a comply or explain basis. They link in the things that are in the guidance: balanced evaluation criteria, early supply chain involvement, a collaborative approach, the use of BIM, combined with transparent decision-making and wide consultation. They endorse FAC, bless them for that, but that is only an aside. And as I say, the industry support them. Look, this is a serious moment in the evolution of procurement. I've banged on about collaborative projects for a long time. I've shared case studies and proof for 20 years. Some people are up for it. Some people see it as a bit airy-fairy or irrelevant to their needs. And some people involved in housing development are more interested in financial close and quite sort of macho behaviours. And that includes people in housing associations as well as private developers. We have to get them on board with the idea of iterative processes that in the world of mergers and acquisitions would be due diligence. And this is my Bermuda Triangle. We need to escape the notion that collaboration is a matter for some idealistic debate, some cynical criticism, and then unrealised good intentions. And I would say that that mandate in the playbook and the links to the Building Safety Act gateways, if they're implemented, will do that. To conclude, I spoke, as I say, to the Department for Levelling Up yesterday, the day before yesterday. They said Health and Safety Executive have picked up on this guidance now and are exploring how to bolt these questions into the gateways. So let us hope that's what occurs. Thank you very much.
Thank you very much. We'll take questions at the end once all the speakers have given their presentations. Well, we've heard how procurement can be used to achieve better safety for our buildings. And we're now going to hear about enforcement means through regulation and legislation. Abdul Janadu was called to the bar in 1995. He has been a practicing barrister and arbitrator in Keating Chambers since 1996, specialising in construction, engineering and energy disputes, and domestic and international arbitration. He is Secretary Pro Tem of the Society of Construction Law in Nigeria. He is a member of the Court of the Lagos Chamber of Commerce International Arbitration Centre, a member of the Lagos Court of Arbitration, a member of the Advisory Board of Africa Construction Law, and has been appointed to the Directory of African International Arbitrators. He is also a Fellow of the Chartered Institute of Arbitrators in the UK and the Botswana Institute of Arbitrators, as well as a TechBar accredited adjudicator. He has also contributed to Keating on construction contracts, Keating on offshore construction and marine engineering, Keating on NEC, and oil and gas contracts, principles and practice. And I now hand over to Abdul to explain to you the details of the legislation and regulations coming down the line.
Thank you, my lady. I should start with a trigger warning. I'm going to be talking about fires and residential fires, and there'll be pictures of fires in which people have passed away. So I hope that doesn't upset anybody with that. I should just give you a warning that's coming. I come to this topic having been instructed over the last 3 years or so as one of the counsel on the Grenfell inquiry, acting for the bereaved survivors and residents. And it's safe to say that there have been many jaw-dropping moments in the evidence that the inquiry has heard. And one remark that keeps coming back to me was one of my leaders on the Grenfell inquiry said that what we have on Grenfell wasn't a failure of the system, it was the absence of a system. So when you look at the cascade of failures that led to the deaths of the people in the fire, it's clear that the system simply was not fit for purpose. So my function in the time I've got is to review the building safety regulations over the last 35 years. And building control is one of the oldest forms of local government responsibility in England, and it stretches back to the 12th century. The earliest building regulations are associated with Henry Fitzalan I, Mayor of London, who, in his assizes of building contentions, made a regulation regarding the dispute arising from boundary disputes between parties. What this seems to demonstrate is that, certainly as far as back as the 12th century, neighbours have been arguing about whose responsibility it is to fix the garden fence. However, but the impetus for building regulation has not always been so mundane. We have here a slide showing the Grenfell Tower, and we're all aware of the circumstances of the fire. At 52 minutes past midnight on the 14th of June 2017, a fire broke out on the 4th floor of the Grenfell Tower in Kensington, West London. The fire was started by an electrical fault in the refrigerator, and it spread rapidly and soon engulfed the 24-storey building. It led to 72 people dying, 70 were injured, and it was the worst residential fire in the UK since the Second World War. Earlier this year, the Building Safety Act 2022 was enacted, and it represents, I think, the most radical shake-up of building regulations for almost 40 years. Sadly, for the residents of Grenfell, the Building Safety Act came too late. And in the history of building regulations, and this is the central theme of this paper, the story is all too familiar. The foundation stone of modern building regulation is tragedy. Not just its foundation, but its four walls, its stairwells and ceilings. Tragedy has shaped and continues to shape the buildings in which we live, work and congregate. What is clear is that there's never been a holistic strategic review of building regulations in England. What's happened over the years has been a reactive approach to individual tragedies. However, while tragedy is a driving factor, there are other two forces which bear down on building regulations. One is cost, and the other is control. So, in essence, who gets to say what happens and who pays for it? This talk, it will trace three broad areas in building regulation. Piecemeal legislation. Firstly, we'll look at the earliest history of building regulations, and we'll see that from the outset, the impetus of change has been disaster, followed by piecemeal legislation. Secondly, we'll look at the seismic shift in building regulations under the Thatcher government in the 1980s, where we see a pattern of continual deregulation, giving priority to cost reduction and autonomy over safety precautions. Finally, I'll then consider some aspects of the Building Safety Act 2022 and look at how those changes address the shortcomings in the preceding regime highlighted by the tragedy at Grenfell. So the Great Fire of London, I think one can trace the genesis of modern building regulation back to the aftermath of the Great Fire of London. The fire started in the early hours of Sunday, 2nd of September 1666, and it was a hot, dry, and windy day, giving perfect conditions for the fire to spread. A spark shot out of the oven from the King's Baker and ignited lying fuel nearby. The fire burnt for 5 days and incinerated 13,000 wooden houses, 87 churches, including St. Paul's Cathedral, and 85% of London was destroyed. Londoners fled to the outskirts of the city. Some stayed there for months, even years, until they were satisfied it was safe to return. If the Great Fire of London was caused by a spark, it was spread by chaos. London at that time was a sprawl of tightly packed wooden buildings, and once the fire started, it was unstoppable. The fire led to the London Building Act of 1667. When Parliament decided to act, it passed the act, and this required all houses to be built of stone, and it meticulously specified the number of stories, width of walls, etc. The difficulty with the act was that, although it provided for surveyors to enforce its provisions, when the 3 surveyors who were initially tasked with overseeing the information died or resigned, they were not replaced. So effectively, the act went into abeyance until the acts of 1772 and 1774, from which the legislature had obviously learnt its lesson, and it learned that if building regulations were to be effective, they had to be adequately enforced. Following the London Building Acts, building regulations sprang up throughout the country. So in 1778, we had the Building Act in Bristol, in Liverpool, and one of the other impetuses for local authorities issuing building regulations was the spread of cholera. There was an outbreak of cholera in the 1830s, which led to the death of 52,000 people throughout the country, and this led to the enactment of the Liverpool Building Safety Act, which I mentioned earlier. Moving on to the 20th century, we had an attempt with the Public Health Act in 1936 to introduce a nationwide system of building regulations that required all local authorities to adopt building bylaws by 1939. However, by 1939, obviously, more ominous threats had arisen, and the issue of building regulations was put on the back burner. The scheme was revisited in 1953, but its adoption by local authorities remained discretionary. The piecemeal nature of the development of the building regulations is illustrated by a number of particular events. So in 1956, we had the Eastwood Mill fire in Knightley, where there was a fire in which 8 people died, and the fire inspectorate carried out a survey of 40 to 50,000 premises off the back of that tragedy. As a result, we got the 1961 Factories Act. The Act introduced new rules governing the installation of fire alarms, enhanced requirements for providing adequate means of escape. In 1960, we had the Henderson & Sons fire in Liverpool, where a department store went up in flames. 10 people became trapped and perished on the 4th floor, despite the fire brigade having attended fairly rapidly. In the wake of this tragedy, you had the 1963 Officers' Shops and Railway Premises Act. You then had, in 1969, the Rose and Crown Hotel in Saffron Walden, where on Boxing Day, there was a fire that led to the death of 11 people. At the time, the hotel had no proper alarm, no fire doors, no emergency exits. This was one of several hotel fires which led to the passing of the Fire Prevention Act in 1971. The Public Health Act of 1961 was the first time, which for the first time gave the Minister for Housing and Local Government the power to make national regulations. The Act repealed the power of local authorities to make local building bylaws, and the first national building regulations were issued in 1965. The regulations were highly prescriptive, and they contained rules and standards that had to be followed. That approach continued for less than 20 years, because in 1984, we got the Building Act, which was passed during the Thatcher government's deregulatory drive, and this introduced a radically different approach to building regulation. Sorry, in December 1979, the then Secretary of State for the Environment, Michael Heseltine, gave a speech to the NHBC, which began, "I want to speak to you about a field in which we can take constructive action. It's important for this industry and needs attention. I'm speaking about the system of building control. Does it serve us well enough? Does it address itself the right objectives? If not, how can it be improved?" What the government of the day outlined was a new system of building regulation, one that was characterized by maximum self-regulation and minimum government interference. The new regulation that the government proposed would be totally self-financing and simple in operation. And the scheme would have 2 main consequences: slashing cost to government and decentralizing control. Now, in my view, the speech marked a watershed in the history of building regulation, because the changes that followed were radical and far-reaching. In 1981, the government presented a white paper, The Future of Building Control in England and Wales, to Parliament, followed by a bill that included the part privatisation of building control to private certifiers. And the Building Act, enacted in 1984, was the first comprehensive primary legislation for building regulations in England and Wales. The building regulations in 1985 were introduced the following year. The new regulations were designed around a performance-based system. So rather than setting out prescriptive rules of banned materials, as the 1965 regulations had done, the new regulations outlined broad outcomes which buildings must achieve, and it was left to industry to work out how these standards were to be met. And existing guidance was cut down from 306 pages to 24. And importantly, the monitoring and implementation of building safety standards was taken out of the hands of local government and given largely to private certifiers. The story of Approved Document B is one of progressive deregulation, decentralization, and in my view, ultimately disaster. The story of Approved Document B is the story of Grenfell. In the new regulatory scheme, building requirements were set out in approved documents. If these standards were met, no one could be held legally liable for problems that might ensue. But these standards were not technical, they're performance-based regulations which created, in my view, uncertainty. A paragraph at the beginning of each of the approved documents explains their purpose. It says, the approved documents are intended to provide guidance for some of the more common building situations. However, there may well be alternative ways of achieving compliance with the requirements. Thus, there is no obligation to adopt any particular solution contained in the approved document if you prefer to meet the relevant requirement in some other way. Approved Document B sets out standards relating to safety, fire safety, and it was revised in 1992, 2000, 2006. With each iteration, the safety standards governing external fire spread became progressively weaker. And here we focus on particular the definition of Class 0 or Class Not, as some people call it, but I call it Class 0. ADB 1985 stipulated that the external cladding products must be of limited combustibility, and sections A13 and Table A6 of Schedule A provided that Class 0 materials must meet this standard. However, the Fire Brigades Union made it clear that Class 0 in and of itself was not equivalent to a material of limited combustibility. A material of limited combustibility is usually a material that is either totally non-combustible or one that contains a small amount of combustible material. Combustible materials such as plastics are not materials of limited combustibility. They can achieve Class 0 performance by adding fire retardants or covering them with a metal foil. A combustible material can therefore achieve a Class 0 rating as defined by the regulations, yet still be added to a building while being a fire hazard. In 1982, limited combustibility was applied to insulation. In ADB 2000, after the fatal fire at Greenock Court in Irvine in 1989, the limited combustibility requirement was again significantly weakened. Now, at Greenock Court, there had been a fire which destroyed flats on 9 floors of the 14-story building, killed a disabled 55-year-old man, injuring 5 others, and it spread up the building within 10 minutes. A parliamentary inquiry into the fire was conducted by the Cross-Party Environmental, Transport and Regional Affairs Committee. The inquiry heard evidence from the building research establishment, the body responsible for designing and implementing the fire safety tests. Now, it's instructive to bear in mind that shortly before this, the BRE had been privatized. It was now charging manufacturers £15,000 to carry out fire safety tests at its laboratory in Watford, the only suitably qualified facility in the United Kingdom. As part of its development of the fire standards, the BRE developed a new test, one that allowed large-scale testing of external cladding products. The Greenock Court inquiry conducted a review of Approved Document B and adopted the BRE's large-scale test, which was then called Fire Note 2, but then became the notorious BS 8414 as an alternative path to compliance. Here, it's worth mentioning the role of the BRE. The evidence was heard during the Grenfell inquiry that the procedures of the BRE were so lax that they did not have a control over what materials were brought into their burn hole. They allowed manufacturers to construct the rigs that were being tested, and they took on faith the descriptions of the materials and the setup that had been tested, which was given by the manufacturers. The BRE would then conduct the test and then give its authority to the test, not knowing what had actually been tested. It's also worth bearing in mind that because of the commercial nature of the tests, the BRA was now also subject to contractual confidentiality. If the release of the results of the tests was entirely up to the discretion of the manufacturer. So if a particular setup failed the test, there was no obligation on the BRE or the manufacturer to release that information. In addition to the test path to compliance, the ADB 2000 also narrowed the scope of the limited combustibility requirement for installation by limiting it to ventilated cavities only. Now, it's important to mention that at this point, Scotland took a different approach. Since 2005, the Scottish building regulations have required cladding and insulation on high-rise domestic buildings to be either fully non-combustible or that the entire system must be subject to a full-scale fire test. It is worth noting that after Grenfell, 300 social housing powers in England were found to have potentially dangerous cladding. Guess what the number is in Scotland that were found to have dangerous cladding? 0. ADB 2006, a new version of the guidance was brought in 2006 following the Kyoto Protocol, where the United Kingdom signed up to various obligations to reduce emissions. And one of the ways the government sought to achieve this was by the greater use of insulation in people's homes. The new ADB in 2006 had two important changes. Firstly, it expanded the alternative test route to compliance for insulation, as well as external surfaces. Limited combustibility was no longer a requirement even for insulation in ventilated cavities. So for the first time since 1991, manufacturers will be permitted to fit combustible insulation to walls. Secondly, it made a subtle change the wording of the test route requirement. It no longer required large-scale tests. All it required was large-scale test data. Now, the second change was important because it opened the gateway to desktop studies. Now, why are desktop studies so controversial? Well, in essence, we look at the genesis of desktop studies. It was linked to a closed-door industry consultation run by the BRE, which included representatives from the combustible insulation industry, previously prevented from supplying high-rise developments. Cladding and insulation manufacturers had argued that it would be impractical to test every possible combination of materials. Therefore, they brought in the desktop study route. The use of desktop studies meant that data from materials previously tested could be analyzed in order to make a judgment as to whether a new combination of materials would pass if it was tested. And in 2014, the Building Control Alliance, which represents building officials, agreed to formalize the approval of cladding through the use of desktop study reports. The BCA guidance note initially said that the desktop studies had to be carried out by laboratories accredited by UCAS. A year later, that requirement was dropped, and all the BCA guidance note required was desktop studies to be carried out by a suitably qualified fire specialist. On Grenfell, Ceratex's RS5000 passed one of these tests, these desktop study tests, in 2014, when combined with cement fire cladding, a material much less flammable than the cladding used on Grenfell. In January 2018, so after the fire, the manufacturer revealed that it had inaccurately described this test in marketing its products, and the test was withdrawn. The exact inaccuracy has still not been revealed by Celotex. We move on to the Lacknell House fire in 2009. This was a fire in South London on the 3rd of July 2009, and it should have precipitated a radical replacement of the building of fire safety regulation, but it did not. The fire started in a television. Very soon the fire reached a cladding panel on the outside of the building. It tore up the outside of the building. Within 2 hours, 6 people were dead, including 3 children. A subsequent investigation revealed that the window panels in Lacknell House did not meet the Class 0 standard. In 2013, the coroner, Her Honour Judge Francis Kirkham, overseeing the investigation into the fire, recommended the government review approved document B, describing it as the most difficult document to use. The all-party government on fire safety sent numerous letters to ministers calling for a review. As late as 2016, so less than a year before the Grenfell fire, the then housing minister, Garvin Barwell, made it clear that the promised review of guidance had not gotten underway, but it promised that the review would take place. It never did. The weak enforcement of building standards under the Building Safety Act 1984 had been a broader trend towards deregulation. The well-known drive to deregulate under the Thatcher governments in the 1980s was enthusiastically picked up by the New Labour government in 1997, with the government founding the Better Regulation Task Force, giving it mandate to replace unnecessary regulatory and administrative burdens on businesses. One feature of this was the Regulatory Fire Reform Order, 2005. This is a new key innovation which was intended to consolidate fire safety legislation to a single piece of legislation. And it brought about two changes. First, fire certificates were which had given fire authorities considerable leverage to bring about improved standards were scrapped, and a new risk assessment approach was adopted. Second, the responsibility for ensuring fire risk assessments took place was left in the hands of a reasonable person, usually whoever was in control of the premises. The risk assessment was to be carried out by a competent person who needed to have a sufficient training and experience of knowledge and other qualities to carry out properly. Fire safety assessments became poorly monitored and no longer need to be carried out by trained fire safety engineers. We then move on to the review, the Hackett report, which reference has already been made. The Hackett review has got to be reviewed against the background of the politics of the government of the day. When the Conservative and Liberal Democrats coalition took power in 2010, the Cabinet Office instigated the Cutting Red Tape Initiative. Vince Cable, the then business secretary, became chair of the committee, and he proclaimed that this coalition has a clear New Year's resolution to kill off the health and safety culture for good. The coalition introduced a one-in, one-out rule, which required a regulation to be removed whenever a new one was introduced. And in March 2016, the final touches were being put on the refurbishment of Grenfell Tower. The now Conservative majority government upped its targets to 1 in, 3 out, and promised to save businesses £10 billion by reducing regulation. Following the fire, the interim report by Dame Judith Hackett into the Grenfell fire made reference to her shock at some of the practices which she had heard about. And she said, "I'm convinced of the need for a new intelligent system of regulation and enforcement of high-rise and complex buildings, which will encourage everyone to do the right thing and will hold to account those who cut corners." A government consultation followed the Hackett report, and after a further response in 2020, we got the new Building Safety Act. I'll just run through this very quickly. There are 3 broad categories of changes I want to look at in the new Act. The first, causes of action; second, oversight; and third, new regulations. The Act introduces a new cause of action under section, which will this will allow claims to be brought against construction product manufacturers and suppliers. Suppliers where products have been missold, found to be defective, or there has been a breach of regulations. If this contributes to or causes a dwelling to become unfit for habitation, then a civil claim can be brought through the courts. The next is cause of action, section 38 of the Building Act is brought into effect. This was a provision in the 1984 Building Act, which had never been brought into effect, which gave a right to claim compensation for physical damage or injury caused by breach of the regulations. And then building liability orders. The court can now issue building liability orders, and these apply to corporate bodies and associated corporate bodies. A corporate body is associated with another if one controls the other, or both are controlled by a third party. So a very wide definition of a corporate body that's liable to a building liability order. And building liability orders relate to liability arising under the Defective Premises Act, and Section 38 of the Building Safety Act, or as a result of a building risk, that is a risk of safety of people from fire or structural failure. So then we have the extension of limitation periods. This is a major change in the Building Safety Act because limitation periods will be extended for 15 years for dwellings unfit for habitation under Section 1 of the Defective Premises Act and breaches of building regulations under Section 38 of the Building Safety Act, of the Building Act 1984. Very significantly and unusually, there is an inclusion of retrospective claims. So where a person is entitled to bring an action under Section 1 of the Defective Premises Act before 28th of June 2020, the limitation period is extended to 30 years. And for those who reach the 30-year point between 28th of June 2022 and 20th of June 2023, the 30-year endpoint will be the 20th of June 2023. Oversight. We now have a new building safety regulator. Part 2 of the Act creates the Office of the new building safety regulator, who is responsible for overseeing improvements in the safety and performance of all buildings, and will also enforce a more stringent regime for higher risk buildings. We have a new home ombudsman, who will provide dispute resolution complaint procedures for buyers of new builds against developers, and the golden thread for vital building information, which will, the government guidance insists that the golden thread must be captured and maintained digitally for the entire life cycle of the building. And then we have an accountable person who will be required to have at least one, so all buildings, all higher risk buildings, are required to have at least one clearly identified accountable person who is responsible for ensuring that the fire and structural safety is properly managed for the whole building. This is not the same as a responsible person under the previous legislation. The accountable person is defined under the bill as a person who either has a legal estate in possession of common parts of the building or is under relevant repair obligations, such as the TMO. The accountable person may be an individual, partnership, or corporate body, and there may be more than one accountable person per building. Now, new regulations. New duty holder regulations to ensure the building work, including design, complies with building regulations. During the bill's passage, the government published numerous fact sheets. However, these fact sheets were withdrawn, although they remain available for the time being. One of these fact sheets sets out the purpose of the secondary legislation governing duty holders. It states that duty holders will be clients, principal designers, principal contractors, and contractors. And duty holders will need to work together to plan, manage, and monitor the design work and the building work, ensure they cooperate and communicate with each other, coordinate their work, and have systems in place to ensure that the building work including design work, complies with all relevant building regulations. There's now stricter regulation for higher risk buildings. Crucially, the Act creates a new, more stringent regime for buildings in excess, residential buildings in excess of 18 meters. And in relation to approved document B, it still contains, unfortunately, the reference to use of full-scale test data, which still leaves open the possibility of using desktop assessments. To conclude, therefore, what we've seen in this sort of brief run-through of the history of building regulations in England and Wales is that disaster has led to legislative change. There's never been a holistic review of the requirements for building regulations in relation to fire safety in particular. It's likely that the new Building Safety Act will, through its oversight functions, increase accountability, which will make it less likely that a tragedy like Grenfell will occur in the future. However, it's regrettable that it's taken this long, and the fact that previous warnings, such as Greenock Court and Lackland House, were ignored to get us to this position. Undoubtedly, the other priorities relevant to building safety regulations, the need for cost savings, and the desire for greater autonomy in the selection of building technology will continue to be championed by some. And we still hear siren voices in the present government talking about a deregulatory agenda. The concern is that if these priorities are allowed to weaken the protections which are now afforded by the new Building Safety Act regime, then we will go back to where we were before and end up with more strategies like Grenfell Tower. Thank you very much.
having dealt with procurement processes, regulation and statute regulation, to consider the case law by which we might achieve building safety. And to tell us about that, we have Professor Philip Britton. He has extensive experience in devising and delivering teaching about law in a wide range of areas, nationally and internationally, including via video, most recently in construction law to professional audiences, as well as to undergraduate and postgraduate students. He is a former visiting professor at the University of Melbourne and King's College London. He is involved also in advisory work in law and has a long track record of published research, some prize-winning, including the SCL Hudson paper from the 2018 competition. In 2021, Professor Britton co-authored the first book on residential construction law, comparative across the UK, Ireland, and Australasia. He's also worked for many years as an editor of papers published by the Society of Construction Law, UK and Ireland. I'll now invite him to talk to us about achieving building safety through case law.
Thank you. There's a little technical wrinkle, which is I have to master getting to the slides.
You just click it on. Yeah, that's the right. Come up automatically.
Oh, it'll just come up automatically.
One more.
And it does. Fantastic. Thank you very much, David. I make my usual apology for speaking from a prepared text. It's the only way I can be sure to cover all the points and in the right order. Today, I'm channeling one of theatre's more tiresome and superannuated bit players, the ghost of Hamlet's father. I've been conjured up to stalk the battlements here in a brief return from, in my case, the twilight world of coastal retirement. Like him, I bring a warning of ill deeds needing retribution. Homeowners, both freeholders and long leaseholders, suffering construction defects caused by others, but left with no remedy. It's a gloomy but predictable message, and it shouldn't be. One of the positives of being offered a ready-made title for a presentation is that it encourages looking afresh at familiar material. Residential building law in England, from Anne's to Grenfell and beyond, certainly does that. Here's a brief overview to give you some signposts. The central question is this: how has English law evolved over the last half-century in imposing liability for housing defects? A post-Grenfell trend, including in government, seems to hold that we've done the job if we respond adequately to the risk of danger from buildings, prevention as well as cure. But it's really only cure I'm talking about this afternoon. I'd rather treat danger as one key aspect of a wider goal, quality in general. This topic clearly centres on English law, but that can't be the whole story. Anyone who opens Julian Bailey's magisterial construction law will be persuaded in seconds that comparing one legal system's approach with others adds insights not easily got in any other way. In this presentation, therefore, I can't resist pointing out some contrasts down under. I'd better now unpack the title more fully. Grenfell, of course, needs no explanation. But for non-specialists, Anne's means Anne's and the London Borough of Merton, a case decided in 1977 by the House of Lords, then the UK's final Court of Appeal in civil cases. In the memories of insiders, which means some of you, but probably not all of you, Anne's forms the central item of a common law trio, or arch, inseparable from its prequel 5 years earlier, Dutton and Bognaridis in the Court of Appeal, with Lord Denning in robust form. Both are dramatically overruled by the House of Lords sequel 14 years later, Murphy and Brentwood, about which we heard a little already this morning. But there's a Kiwi coda, Invercargill and Hamlin in the Privy Council, which we also heard mention of this morning in relation to limitation periods. And of course, there's also been statutory intervention along the way, about which we've just heard, most recently in the Building Safety Act 2022. I was already a lecturer in law at the University of Warwick when Dutton was decided. I wasn't, it's true, teaching the law of tort as such, but I've no memory of spotting any of these three English cases when they first appeared. It's embarrassing to acknowledge the scale of my ignorance, but all that changed on arriving at King's and the Old Watch House in 1998 and getting to grips with modules A and B in the MSc, as we then called them. It's been instructive now to reread the whole of Anne's after a very long gap. It has more than just historical interest, as I hope to show. The factual background is utterly unremarkable, routine even, in its story of hidden shortcuts and cost savings. A block of 1960 two-storey maisonettes in London SW19 is claimed to have inadequate foundations, not as deep as the plans had indicated. When internal damage appears in the flats, note that word damage, inspections must have pinpointed its likely source in the foundations, leading in turn to the litigation. The foundations would, of course, have been covered and difficult to check well before construction was complete. Intermediate inspection by the first buyers, let alone the ultimate consumers, would have been neither possible nor reasonable. The claimants, then still called plaintiffs, of course, but they are respondents when we get to the House of Lords, are a group of current long lessees, and they're a mixture of first and later purchasers. Their primary aim, of course, is an award of damages for the cost of rectification. As I've said, liability, if anyone owes it, derives from what happened during the block's original construction more than a decade before. It also explains why Anne's includes a limitation issue, almost a decade before the Latent Damage Act 1986 made a stab at reforming the rules, not, if I dare offer that judgment, in the end doing much good. I'm saying little about this topic today, although such problems, the impact of delay in discovering construction defects originally latent, are often key obstacles, as I'm sure you know, for unhappy homeowners as well as potential claimants generally. Such limitation issues have inevitably been part of the post-Grenfell manoeuvrings by private sector flat owners, often meeting a legal roadblock. Even the successful cladding claim in Martlet Homes and Mullally earlier this year related to only 4 of the 5 refurbished blocks in Portsmouth. A claim deriving from the earliest refurbishment contract had already been timed out. You know more about these issues from Fiona Parkin's presentation this morning. Limitation changes are, as Abdul has said, included in the Building Safety Act 2022. Of these, some have retrospective effect and some impact on Scotland too. Oversimplifying, in my view, none are certain to make much difference to potential claimants, to whom all the usual disincentives against undertaking civil litigation still apply. Negatively, the changes may increase the future premiums those in construction will have to pay for PI cover, or eliminate cover entirely for cladding-related issues. This, forgive me, I've got a page too far. In Anne's, the main substantive law issue for the Law Lords is about the potential liability of the local authority. This comes from its operating, negligently the claimants say, the statutory system of building control at the time. I say potential because the local authority is asking the Lords to strike out this part of the claim as unsustainable in law, even if the plaintiffs can prove all the facts they're alleging. So it's directly analogous to Donoghue and Stevenson 40+ years earlier. The covered-up foundations in SW19 could play a role in the legal argument, just like the opaque glass bottle in the Well Meadow Cafe in Paisley. In both situations, there's an ultimate consumer of the outcome of a technical process who has no choice but to trust the competence of the maker. I say system because the then key statute, the Public Health Act 1936, gives each local authority a power, but not a duty, to adopt its own bylaws to regulate construction in its area. Nor does the statute expressly require, if the local authority does adopt such bylaws, that they be enforced. As is the way, the 1936 Act says nothing, either positive or negative, about the liability consequences. This context to Anne's tells us several important things. First, that the relevant legal framework leading to the answer, we hope, comes from principles developed by judges properly labelled the common law, thus capable of evolution, even revolution, from time to time. The claim includes no reliance on the Defective Premises Act. This legislation, imposing new statutory duties on all those constructing dwellings or being part of the process of constructing dwellings, was adopted only in 1972 and had, on coming into force, no retrospective effect. In 2019, the Court of Appeal told us that it doesn't impose liability on either public or private building control bodies, so in any event, it wouldn't have helped the claimants in Anne's. So the issue is, how can one get from activities empowered by statute to the possibility of tort liability if carried out negligently? Second point about the context, I've sort of just said it, is that in relation to housing quality issues, it may be a claim in tort or nothing. Well-respected judges have said, both here and in Australia, but not thankfully in New Zealand, that claiming in contract is and should be the royal road to judicial remedies in our field. Such a line has ideological purity and conceptual tidiness on its side, but not justice. Its effect is simply to limit the pool of those who can recover. Consider the claimants, well, I would if I could get there. Good. Consider the claimants in Anne's. None of them were ever construction employers in the real sense. Some of them were not around when construction took place, but all now have well-founded grievances against those factually responsible for their homes' build quality. In relation to first buyers, but only in relation to them, the developer's failings would almost certainly have been breaches of terms in each buyer's contract, at least if entered into off-plan. Under better circumstances, the developer, still owning the freehold of the whole development and now its landlord, would be the primary and perhaps only defendant. Even if there's a target defendant against whom a claim in contract could have been mounted, that party may no longer exist, be not worth suing, or such a claim may already be timed out. So the local authority may represent the last person standing, the only remaining chance in fact as well as law for a claim by the flat owners. As a result, the claimants in Anne's, in this part of the litigation, are targeting what we could call a secondary defendant. Their beef with the local authority is that it culpably failed to protect them against what they say was inadequate execution of a structural part of the project by the developer. But this would be the local authority's own liability. It's not vicariously liable for the developer's separate negligence, although the result may look as if it is. If contract is the only legal way forward, most may have no rights at all to assert in court. They simply become victims. At the limit, they may have three other possibilities: a claim on insurance, a third-party warranty or buildings insurance, Government initiatives may help, offering cash or mobilising developers to pay up, or there could be new statutory intervention. All three have been in the news, at least in England, following Grenfell Tower. On third-party warranties, in 2019, the market leader, the NHBC, changed its standard build mark wording, eliminating from future policies the category of cover that would have responded to physical danger to inhabitants resulting from regulatory non-compliance. On government initiatives, the first threats of prosecution of developers for failure to get on with remediation have already been made. But note that, as Abdul has mentioned, in allocating liability for past defects, the Building Safety Act is principally concerned with buildings higher than our flats in SW19 and with defects which compromise safety. The first time that Michael Gove was Secretary of State, he boldly put it more or less like this: justice requires that long leaseholders in residential blocks with combustible cladding or insulation should not get left with the lion's share of the costs either of temporary protection or rectification. And that, of course, is where David Moses' approaches to the process of rectification properly find a place. Grenfell Tower may have triggered all these changes, but with four important differences from the case law that we're discussing. It was a local authority block, let mostly to periodic tenants. It was on any test a high-rise building. The project was one just of refurbishment, and the harm was the actualization of the danger of fire. But here too, as in Anne's, the residents were in no sense construction employers, though they were on the spot. Evidence to the judicial inquiry, as David has mentioned, amply shows how little input they had to the project's design, specifications, and implementation. The result was not an unwelcome and unaffordable bill for rectification, instead, loss of possessions, injury, and death of loved ones. Strangely, the law, both criminal and civil, is more obviously on their side than if they were now facing a rectification project and claiming its cost as damages. It may be much easier to show a duty of care in relation to negligent construction or supervision of construction in relation to danger, even more so where physical injury and death have already occurred, than just in relation to defects without those consequences. To fix sources of mortal danger to the outside of a tower block surely prevents the flats meeting any standard of habitability, and landlords of a tower block owe statutory duties under the Occupiers Liability Act 1957, which looks directly to safety. Several already successful claims by Grenfell Tower survivors against the Royal Borough of Kensington and Chelsea and the borough's former tenant management organisation illustrate the protective impact of these rules, thanks also in part to Abdul's efforts on their behalf. If the claimants in Anne's win the duty of care issue, and if they go on to show that the local authority was at fault, then the local authority, will be liable for any damages validly claimed. English law's joint and several liability principle will make Merton carry the risk that it can't shift any of this liability onto anyone else. Further, a judgment against it is almost certain to be satisfied, not reliably so for any developer or other original project party. But a deep pocket never leads automatically to liability, although Lord Denning found this a very tempting argument against the local authority in Dutton. So Anne's raises two issues the law lords must resolve. First, what are the criteria for imposing a duty of care in tort? And second, are those criteria satisfied in relation to this claim, which is about the statutory supervision of construction work? This involves following or not following the outcome and reasoning in Dutton, 5 or more years before. Here, Sadie Dutton showed that the foundations of her home on the south coast didn't comply with the local authority's bylaws. She argued that the authority negligently failed to notice this during construction. The Court of Appeal imposed liability on Bognor Regis Council for the cost of rectification, minus the small amount Mrs. Dutton had already accepted from the original builder. The first answer from the Law Lords is no surprise, as it comes directly from Donoghue and Stevenson. Is there proximity between the local authority and the respondents? Are they its neighbours in law? If the local authority fails to exercise an appropriate level of care, is it reasonably foreseeable that the building will not comply with the plans or the regulations, the cost of restoring it to the condition it should have been in, then falling on the leaseholders? Answer, it clearly is. The statutory background defines and explains the local authority's role in the project. This leads to a finding of its proximity in law with anyone now owning one of the flats. But English law has, now as then, no general principle that proximity plus negligence equals liability. However, Annes elevates this almost into a presumption, adding in an escape route as its second answer. Are there any factors here, in other words, on these facts, arguing against a duty of care or in favour of a more limited duty? One might be that the original developer owes no comparable duty of care. How could or should the local authority incur tort liability when the developer does not? If we classified the defect as damage to the building, one which could create a risk of injury, then the developer certainly does owe a duty of care, independent of contract, and sounding in damages for the cost of rectification. In line with Dutton, that's what Lord Wilberforce says in the main speech in the Lords. No escape route there, then. We, or at least I, don't know the precise outcome for the claimants in Annes, since they must, as you've heard, go on to prove the local authority's negligence, must show the shortcomings in the building's foundations, and must prove the cost of rectification. We also don't know the fate of their parallel claim against the developer. But the block of maisonettes is still there. And we do know what happened in later litigation and in critical commentary to the principles Lord Wilberforce laid down, a counterblast of epic proportions. The setting for a shift into reverse gear was a nearly identical reiteration of the facts in Annes, but in leafy Essex. The Defective Premises Act 1972 was now part of the legal landscape. And those of you who are here this morning will have had a reminder of some aspects of this very case from Fiona. Did Brentwood District Council owe a duty of care to the later purchaser of a house with, wait for it, foundations that were inadequate, allegedly under-designed, thanks to the negligence of the engineers to whom the council subcontracted the reviewing of the plans? The claimant had to reduce the price he could expect in order to sell the house. Could he claim this difference from the council? A completely differently constituted House of Lords from Annes achieved a reversal. All 7 judges, unusually 7 rather than 5, they reclassified the harm for which the claimants in Annes wanted compensation as pure economic loss. As a result, to establish a duty of care required them to show, or a claimant in that position to show, not just reasonable foreseeability, but that the defendant was in a special relationship with the claimant and those in their position for the functions undertaken. This treats the physical construction of buildings as like the passing on of investment advice. The Law Lords' fear of expanding circles of liability justifies, they think, controlling tightly the extent of any possible duty of care. Put another way round, had the current claimant in Brentwood reasonably relied upon Brentwood, the council, and its subcontractors not to be negligent. Not so, say the Law Lords, expressly overruling both Dutton and Annes. In turn, cases in other fields relying on those appeal judgments similarly become unreliable. This approach is supported, or at least the Law Lords say it is supported, by the limited scope of the Defective Premises Act 1972, which, they say, provides no encouragement for recognising a wider common law principle applicable to all buildings. In English law, and apparently Scots law too, although not so clearly in Ireland, this closes the door firmly against all claims in negligence by homeowners against building control bodies, private or public, for the cost of rectification or for the drop in value caused by the home's non-compliance with mandatory construction standards. In the more than 30 years since Murphy, there's been no serious head-on challenge to this orthodoxy. There is, however, copious recent case law at Supreme Court level on how to get from a statutory scheme to a common law duty of care in relation to different categories of harm, none of it directly about defects in homes. In 1996 comes, as some of you will already know, Invercargill and Hamlin. Here the law lords, wearing Privy Council hats, willingly validate New Zealand's continuing attachment to Anson Merton principles. And you can see, therefore, why I like the case as much as I do. The Court of Appeal in Wellington had upheld an award of damages to Noel Hamlin for the cost of remaking his bungalow's foundations, the City of Invercargill's inspectors having failed to notice that their actual depth was only about half what the plans and the bylaws required. Later on, as the flood of leaky building litigation starts in New Zealand, the New Zealand Supreme Court puts the general principle this way: statutory building control is for the benefit of building owners and users. Where negligence results in a building being non-compliant, the person or body responsible owes a duty of care, measured by the cost of making the building compliant or the drop in its value. I'm therefore suggesting, as the first of a series of final points, that the current English and Scots version of the common law fails many of our homeowners. It impacts most clearly on those like some but not all of the claimants in Anne's, those who have no right of action in contract and whose homes, when new, would have been in breach of any developer's construct and transfer off-plan sale contract, or which remain in breach of the mandatory external standards of the time. I understand the reasons given, but the result is an unfilled legal gap, making any promise to consumers of enforceable basic construction standards simply a hollow boast, even as the new regulator arrives on the scene. The BSR may transform the landscape in relation to prevention, and of course, like everybody else, I hope it does, but it's not going to change the possibilities for cure if, or rather when, prevention fails. I'd add that, in my view, the Defective Premises Act fails many homeowners too, at least as currently interpreted by the judges. So extending the DPA to future refurbishment work will not make much difference, nor will activating the Building Act 1984, Section 38, except perhaps where death or personal injury has in fact already occurred. The overall inadequacy of English law becomes clearer if we look at kinder and more protective regimes down under. As we already know, the common law in New Zealand has a generous concept of duties of care in construction. By contrast, God willing, I'm sorry, any thought, David? It's something to do with, well, I don't know what it's something to do with. It's something to do with technology. Thank you. I'm sorry? Clearly so. I know. Well, age, it's one of the many features. So, by contrast to New Zealand, Australian tort law adopts a narrow view of construction situations giving rise to a duty of care in relation to defects, closer to English law. But and again. There's something magic that... There must be a word I should be saying under my breath, I think. By contrast, all states and territories, except Western Australia, impose a set of mandatory contractual obligations on the builder in residential situations. By law, the benefit of these statutory warranties in a contractual but not insurance sense is transmitted to the current building owner, who can rely upon them to start legal action within the limitation period, which is often a fixed 10 years. New Zealand adopted a different but comparable statutory regime in 2015. Homeowners seeking judicial remedies for defects in UK homes are therefore the poor relations of their equivalents down under, as well as of most commercial and industrial consumers of construction. Commercial players more often have contractual rights of action against project parties, either in their own right or via assignment or via third-party rights, with additional possible rights under collateral warranties. Together, these fill the gap left by Murphy and Brentwood. Even if homeowners had additional rights of action in relation to defects, many would still be first-time litigants taking aim at well-resourced repeat players. Transcending their own vulnerability would remain for many, as now, too great a struggle, just as it is to find skilled and affordable professional reputation. So, any cheery points to end on to address the "and beyond" in my title? Well, the Building Safety Act ought to raise construction quality generally, so the sorts of residential problems that led to the case law I've discussed might actually occur less often. And the new Act includes powers which could be used to impose a set of enforceable obligations on all developers of new homes in relation to not just build quality, but also the sales process. And that would bring with it free-to-access remedies from the New Homes Ombudsman Service for the first 2 years, note, sadly, 2 years, after the home's first sale. Separate powers in the BSA could also be used to require every new home to have a qualifying 15-year insurance-backed warranty. But there's no sign of eagerness in the present government to activate either of these possibilities, and they would apply only to future new sales. No substitute, in a word, for adequately defined quality obligations protecting every homeowner for at least 10 years, with accessible methods of enforcing them and reliable remedies. So, back, I'm afraid, to the common law, but I'm hearing a distant cockerel crowing. As Shakespeare tells us, when dawn approaches, ghosts melt away. However, bear in mind that the part of Hamlet's father is often doubled on stage with that of the gravedigger, and you know what a gloomy and sardonic fellow he is. Thank you very much for listening, and on the screen, wait a moment, you have my email address if you want to be in touch about any of the topics I've touched on today. I'm also on LinkedIn, where you'll shortly be able to read an extended version of this presentation. Thank you.
Well, I'm sure you will all agree that we have had a wealth of information, advice, guidance through the presentations that have been given by our three wonderful speakers. We're eating into your afternoon break, and so can I just ask whether anyone has a question? We have time, I think, maybe for one question. No, you're stunned into silence. Well, can I just then conclude by saying two things? First of all, in the wake of the Grenfell tragedy, I think most people would agree inaction is not an option. what we have had presented this afternoon is a number of options, from getting in at the design stage to ensure that we have safe buildings in the first place, to having oversight during the construction process, and to have adequate remedies for when things go wrong. I remain optimistic that although Grenfell has been a terrible, terrible tragedy, that people recognise it must not be allowed to happen again, and that we can find a way to fix the problem. So can I just invite you again to thank all of our speakers.